Case number 1667. Oh. Thank you.
Here's that paperwork now. Here's that paperwork.
Excuse me. Case number 166750, People versus Charles Pugh. This matter before the court for motion.
Good morning, Judge. Ralph Elizondo, Assistant Prosecutor.
Danielle Bennett on behalf of the people, Judge.
Yes, good morning, Your Honor. May it please the court, Delphia Burton, appearing on behalf of and with Mr. Pugh.
Good morning. You can be seated. We are here today for a number of motions, including a motion to quash and a motion to dismiss due to a statute of limitations violation. What I'd like to do, since at least some of those counts are interrelated, I'd like to hear from the parties as to both of those issues, and then I'll rule at the conclusion of hearing argument as to both of them, since they are, at least some of the counts, interrelated. I'm prepared to hear whichever argument you'd like to make first.
We can start with the motion to quash.
That's fine.
Your Honor, it's our position that there was an abuse of discretion by Judge Deborah Lewis Langston, who was the examining magistrate at the preliminary examination, which was conducted on August the 5th, 2016. Mr. Pugh has multiple charges, counts 1 through 3, first degree criminal sexual conduct, and counts 4 and 5, criminal sexual conduct in the third degree. Count 6 was dismissed at the preliminary examination. Notwithstanding that, we still submit to the court that there was an abuse of discretion in binding Mr. Pugh over, first as it relates to the counts related to first degree criminal sexual conduct. This court, I'm certain, has read the transcript, so I won't be redundant and repeat the things that have been said. The basic crux of the people's case is that there was a position of authority, or that there was another felony that was committed that would elevate the sexual penetration with an individual between the ages of 13 and 16 from a third degree CSE to a first degree CSE. So I'll deal with the issue regarding the position of authority first. Your Honor, the people's position was that Mr. Williams, Austin Williams, the complainant here, was an intern for Mr. Pugh. Now, it's ironic that during the preliminary examination, he was the intern. Later on, in terms of the pleadings that had been filed or responded to, then he became a quote-unquote personal assistant. I submit to the court that the mere fact that an internship is uttered doesn't make it an internship. We have an individual who approaches Mr. Pugh. Mr. Pugh is not seeking Mr. Williams out. He approaches him, and if he says it was about an internship, alleging to be 14 at the time. I don't know how many 14-year-olds are looking for a quote-unquote internship. Perhaps he was looking for some work, but the main thing is that the evidence that was revealed at the preliminary examination indicated that he carried Mr. Pugh's bag, carried a makeup bag, I believe he carried a bag for a cameraman, he put together a desk, and he allegedly cleaned his apartment. Judge, I submit to you that those things do not constitute an internship. Those things do not place Mr. Pugh in a position of authority. Now, the cases that deal with position of authority look at whether or not the person perhaps is in some sort of supervisory capacity over the individual. So therapists, where there's a relationship that's there, coaching, as in the Reed case has been mentioned, but not where there's a sporadic contact with someone. You would look at things like, and I've mentioned a number of them in the motion, Your Honor, on page 6. He did not work at Fox 2. He did not sign any paperwork with Fox 2, nor with Mr. Pugh. He did not have to write a paper or an essay, which is sometimes something that would be required with an internship. He did not submit any documentation to his school to receive any credit to be applied for community service or as a quote-unquote working as an intern. He did not answer any phone calls, had to check any emails. He didn't do anything as relates to putting together Mr. Pugh's schedule or answering emails. Did not, according to the record, receive any financial compensation. Did not have any defined duties nor responsibilities, and did not even have a specific work schedule. Mr. Pugh was not in a position where he could impose any discipline upon this young man, other than you fire somebody, quote-unquote, if they work for you, but it wasn't even that type of relationship that was revealed. It was something where he was helping out, but not in an authoritative position or supervisory capacity, which is being alleged by the people. I think the record is void of that as related to any position of authority, and it's really an argument just so they could try to elevate the CSC 3 to a CSC 1. The mere fact that it's said doesn't make it so, and I know the court says, well, ultimately, things go before a jury and they make that determination. But I think that the threshold has not even been met in order to even present it to a jury, and I'm asking the court to dismiss counts 1 through 3 on that basis. They also have an alternative argument relating to the accosting, soliciting, and enticing, and I believe that's under MCO 751.45A. Now, there's a problem related to statute of limitations, and Your Honor, it's more or less that I'm preserving the record because I understand the arguments related to that. I have a problem personally with old cases because it places a defendant in a very precarious situation in which not able to really defend themselves. How many of us really keep a record of what we've done last week? If it wasn't for the fact that we were lawyers, I wouldn't carry a planner. And so to say that you can know what you've done, have a record of what was happening 10, 12, 13 years ago, it's really a very difficult situation. And that's one of the reasons why they have statutes. That's one of the reasons why it's imposed. It's not just for the complainant, but it's for the defendant in terms of being able to prepare a defense. And ultimately, the 14th Amendment should always prevail in terms of the fundamental fairness that Mr. Pugh and actually all the parties involved are entitled to. Nevertheless, Judge, when we look at the particular charge under 750.145A, it's barred by the statute of limitations because it was not charged, for one, because it's a 6-year statute of limitations relating to that charge. So they would have had to have filed that charge by 2009 or 2010. So that was not done, and here we are, and it was not raised in 2016 when the warrant was issued, I believe on June 22nd of this year. The problem, of course, that counsel has, and I'm just going to state it for the record because I recognize the position that we're in, and I'm very transparent. I'm not going to insult the court's intelligence as it relates to the tolling of the statute. And that's the primary problem that we have here because the statute says once an individual leaves the jurisdiction that your time bar pretty much or the time stops. That's also found under 600.5856 that deals with the tolling of the statute. It's also contained within the 767, I believe 24, dealing with the statute of limitations. And so that argument is made, Your Honor, notwithstanding the fact that the legislature has ruled. They amended the statute in 2001, giving more latitude, extending the time from the 10-year on the CSC first degree up until life, or forever. You can bring that charge at any point in time. The CSC 3, 4, 2, 3, and 4, and then that was broadened from the 6-year to the 10-year, or before the individual's 21st birthday. So while the time would bar them, and they would have to dismiss the case, unfortunately, if there's an argument relating to or issue related to the actor leaving the jurisdiction, then the statute is tolled, and the argument becomes moot. I do want to preserve it for the record because there are always issues that are being raised, and sometimes they're not always prospective, but they're retroactive. And so I'm preserving that, making a record, but indicating to the court I understand the position that we're in, but I do still believe that counts one through 3, the position of authority is an argument that just doesn't hold muster. And also the conclusion of the argument, notwithstanding the fact that there's a statute of limitations issue relating to counts 4 and 5, I still think it's more prejudicial than probative because the courts will still have to do the balancing test as to whether or not that information should come in. And so with that, Your Honor, that's our position as it relates to all of the charges. We do believe there was an abuse of discretion, and we're asking this honorable court to dismiss the appropriate charges. Thank you.
All right, so you've dealt with both the motion to quash and the statute of limitation issue.
Correct.
All right, response?
Thank you. I think that I've placed basically what I'm going to say in my brief, and I know you've read it, so I'm just going to just kind of highlight a couple of issues or areas. Number one, as to the statute of limitations, our position is simply that the statute does talk about tolling. At that time where a person lives outside the state is not to be counted within the time that's ticking off as for the statute. Our position, Judge, is that we have evidence to indicate that the defendant left the state of Michigan sometime in June of 2013 and lived outside the state from that point until actually he was brought back to court here just recently. Our position is that the case law in this state indicates that that's a question of fact. Well, first of all, raising the statute of limitations is an affirmative defense. The counsel has a right to raise, but that is a defense that should be raised at the trial level. And that is a question of fact, and it is a question for the trier of fact. And we, in our brief, submitted the case law that we felt substantiated that. I'm not going to go into that because I know you read that, Judge. Our position is that the statute, again, that's a question of fact as to the statute of limitations. As a result of that, these charges, the two counts 4 and 5, should be allowed to go to the trier of fact and let them determine whether, in fact, the statute had run based on the evidence that we would present at that time. As to the motion to quash, and again, Judge, I included in my response the authorities in which I relied on in this to substantiate our case. And if I'm going to begin with the standard of review at this point of the game. District Court's decision to bind over a defendant is reviewed for an abuse of discretion. And the leading case is People v. Hamlin, 224 Mishap 87, it's a 1997 case. An abuse of discretion occurs when a court chooses an outcome falling outside the range of reasonable and principled outcomes. People v. Babcock, 469 Mishap 247 also takes that position. So that's what we're asking this court, and I think what this court needs to do is frame the arguments accordingly as to whether or not, based on the evidence that was submitted at the preliminary exam, that the magistrate erred based on that standard. As to the argument as to the position of authority over the complainant, counsel argued a lot, or talked a lot about our theory was a position, he was in a position of authority because of his internship, of work related. I think the case law looked at, and then specifically People v. Reed, 223 Mishap 457, looked at the concept of a person being in a position of authority over another individual. And in that case, they looked at factors that would lead a person to believe that a minor had been placed in the defendant's authority, a position of authority, that he was placed into a situation where the defendant would have authority over him. And in that particular case, as I cited in my brief, they talked about looking at the understandings that the individual had, the defendant would have vis-a-vis the parents of that individual. In Reed, they the defendant held himself out as a counselor and told them that he counseled their child about their problems, and both parents expressed an understanding that the complainant would be spending time with that person for that purpose. Here, we have a situation where the defendant put himself in a position where he indicated that he would be offering this, the complainant in this case, a job or to work with him and to be available. And I've cited the various references in my brief as to where that's found in the transcript. That the defendant met with the mother, that the defendant talked to the mother. And all of that was, both of those situations were instigated, according to the testimony of the complainant, by the defendant in order to make sure that this was okay. And that discussion all was frameworked around the complainant's understanding that he would be going with the defendant to work as an intern or to work as a gopher, as was testified. And that the reason the mother let that occur was because of the conversations that she had with Mr. Pugh, outlining what and why they would be spending their time together. Then we go on to the next part about the coercion and the coercive aspect and I think that it was clear from the testimony that the complainant had a feeling that if he did not comply with the actions and the things that were occurring, if he did not engage in those actions and activities, that he would not be, that the relationship and the job, or whatever you want to call it, would cease to exist. And again, I put in my brief different areas where that testimony was made. So it was essentially, in a sense, and I think one of the sites I put in talked about constructive, coercive behavior, and I think it fell within those constructs. And as a result of that, Judge, I believe that it existed at least sufficient for that trier of fact would be in the magistrate to conclude that the position of authority was in place and that was utilized in order to coerce the oncoming sexual behavior that was alleged to have occurred. As to the last argument of complainant of the defense, they're indicating that statute of limitations should bar, because the statute of limitations had run on the predicate felony for criminal sexual conduct in the first degree, that being the soliciting, enticement, etc., that should be kicked as a result of that. And I cited my authority here where the underlying predicate felony, the fact that the statute of limitation was barred on the underlying felony did not preclude prosecution on the felony itself. It was a case I cited, Judge, was a felony murder case with a home invasion predicate felony. The statute of limitation had run on the predicate felony. The Court of Appeals found that it didn't matter, that we could still proceed because that was just a factor in the entire case here. So I believe that argument falls based on that, Judge. And again, I included that in my brief. As to the, let's see here, the lack of enticement or the lack of crime, and I think that was implied in here. And again, I included in my brief the various times, in particular when the first allegations of criminal sexual conduct involving penetration occurred. The testimony was that the defendant asked the complainant if he wanted to see a video. The testimony was that after the complainant agreed to view the video, that the video was a pornographic video. It involved actions of oral sex and then anal sex. The testimony was by the complainant that after viewing the video, or while viewing the video, the complainant testified, he, meaning the defendant, asked me if I wanted to do that, pointing to the video. That, Your Honor, I believe is solicitation. It was solicitation of a sexual act, and I think it meets the definition of that. And it's sufficient evidence for that magistrate to have believed that that was sufficient for the bind over, at least as to that count, for that particular theory. The count 3, there was testimony by the complainant that after cleaning the apartment, the defendant asked him if, and this was a quote, I wanted to do what we did last time, and I told him sure. That's a preliminary exam transcript, page 15, lines 24 to 25. Once again, a solicitation for a sex act. The testimony was certainly that the young man was 14 years of age at the time. So I believe that based on looking at the totality of the testimony of the complainant at that point in time, that the trier of fact did not err in finding probable cause that those elements had been satisfied. Essentially, Judge, like I say, I know you've read the brief, so I'm going to sit down at this point, but I believe that the evidence in this that was presented at the exam is sufficient for this court to rule that the magistrate did not rule abuse their discretion, and I'm going to ask you to do that and to deny counsel's motion. And as to the statute of limitations issue, again, ask you to deny the counsel's motion. As to that, if they want to raise it in trial, that's great. We'll have evidence to present at that point to deal with that issue, Judge. Thank you.
Go ahead. Very brief. Go ahead.
Thank you. Just first, as it relates to the statute of limitations, I just want to place this on the record. While the statute says that the actor, the statute is told when the actor leaves the state, I'd like the record to also reflect that the complainant himself was not in the state of Michigan. Also, at the time that the warrant was issued in June of 2016, Mr. Pugh was not in the state. So that argument is somewhat without merit in terms of, well, the person's out of state because the complainant is out of state, and at the time he was out of state, they went to New York to pick him up. So I just want the record to be clear as it relates to that. The motion to quash would also like to highlight the fact it's not just being placed in a position of authority, but it's what does the actor do to cause the individual to submit to that authority. And there's nothing on this record to indicate that. He said, well, this is how I felt. I felt like I wasn't going to be able to work, or I felt, something would happen. When he was questioned on cross-examination, he clearly indicated that he didn't know his family, he hadn't met his family, and had not received any threats from his family. And so, it's not about necessarily what the individual is feeling, more subjective. It's what the actor is doing, those acts which the record is void of. So, also as it relates to the mom, the mother was busy taking pictures with Mr. Pugh and getting pictures, and so she knew he wasn't working at Fox 2, and to say that, oh, his mother's placed him in a position of authority, she was just happy, her son was hanging out with a celebrity. She knew he wasn't, quote unquote, working and with no internship. They just say that, and the mere fact that you utter those words, it doesn't make it stick. They feel like, okay, we just throw a bunch of stuff up in the air, then, something should stick, but that's not the way that the law works. You need proof, you need evidence, and while probable cause is a low standard, it's still a standard. It's still a threshold that must be overcome, and it's our position that that was not done. So it's conjunctive. It's not position of authority or submitting. Those two go hand in hand. Neither are present here. And if one is viewed as, position of authority, you still don't have a record which indicates that there was some sort of act on the part of Mr. Pugh. There was no exchange. And Judge, also, solicitation from a legal perspective, it's a little more that's required. And so you know, Mr. Pugh, there was nothing that said he asked, you know, for anything. You know, in return, it was like no demand that was being made. Mr. Court, it's just very weak. You know, it doesn't even meet a threshold as far as probable cause. And I know it's a much higher standard at trial, but oftentimes we end up binding things over which could be quashed early on, because not everything has to go to a jury. When the facts aren't there and they haven't met the threshold, then it should be dismissed, which is what we're asking in this particular case. There's one other point I wanted to make, Your Honor. Give me a minute. Count 3. Mr. Elizondo, bless you. Mr. Elizondo raised the issue regarding the quote-unquote enticement. The record only says, do you want to do the same thing we did last time? Is that supposed to be some sort of enticement? Enticement for what? You know, it's not even laid out and spelled out. And so, you know, you draw inference upon inference, which is precluded, you know, from the court doing. But, you know, Judge, you know, Lewis Langston tended to render her own opinions instead of looking at the law, because at the end she says, well, it doesn't matter, any theory. But that's not how it works. It says specific theories have been defined, and if they don't meet those theories, then this court has the authority to quash the appropriate charges, and I would submit, you know, and ask the court to do that. Thank you.
All right. Defendant is charged with 3 counts of first-degree criminal sexual conduct, 2 counts of third-degree criminal sexual conduct in connection with allegations that the defendant engaged in sexual penetration with the complainant when he was 14 years old and later 15. He asked his court to dismiss criminal sexual conduct first-degree charges because the lower court abused its discretion in finding sufficient evidence that the defendant coerced the complainant by exerting his position of authority, and failed to show that the defendant coerced the complainant during the commission of another felony, that being accosting, enticing, soliciting a child for immoral purposes. Defendant argues also that the criminal sexual conduct third-degree charges are barred by the statute of limitation. For purposes of a preliminary examination, the proofs must establish probable cause to believe that a crime was committed and the defendant committed it. If so, the defendant must be bound over for trial. That's Michigan Court Rule 6.110E. For purposes of a preliminary examination, the proofs must establish probable cause to believe that a crime was committed, as I said. When binding the defendant over to circuit court, there must be some evidence from which each element of the crime may be inferred. Circumstantial evidence and reasonable inferences from that evidence may be sufficient to justify binding the defendant over to trial. If credible evidence conflicts and raises a reasonable doubt as to the defendant's guilt, the issue of guilt or innocence should be left to the trier of fact. People v. King, 412, Mich. 145, 1981. The complainant was the only witness who testified at the preliminary examination. He testified he was 14 years old when he joined a youth theater group through his high school in September of 2002. In March 2003, his theater group went to Fox 2 Detroit to promote his group. He testified that he met the defendant and asked for employment as an intern. He said it was fun. He thought it would be fun and thought it would be cool to work as the defendant's intern. Defendant gave him his business card, which had his cell number written on the back of the card. They exchanged text and phone messages until April of 2003, when the defendant reportedly attended one of the complainant's theater events in Ann Arbor. After the show, the defendant and the complainant discussed the possibility of an internship. For what it's worth, the complainant approached the defendant. During the period that followed, the complainant was excited that he had an opportunity to put this type of internship on his resume, and that he thought it could get him into school quicker. In May or June of 2003, the defendant, at his request, met with the complainant's mother to obtain permission for the complainant to work as defendant's personal assistant or gopher. He was under the impression that this was in connection with Fox 2 because the complainant was told that he would be able to go on jobs with the defendant. Complainant testified that there was an agreement between himself, his mother, and the defendant that the complainant would work for the defendant. On his assignment, he accompanied the defendant to a march on Woodward and a shoot at Hart Plaza. During this time, there was an allegation made that the defendant rubbed the complainant's thigh while they were in the car and then drove him home. In July of 2003, the defendant contacted the complainant to run errands with him and assemble a desk for the defendant's home office on Washington Boulevard. He allegedly picked up the complainant at his house, and the complainant testified after he finished building the desk, the defendant asked him if he wanted to see something and then turned on a pornographic video. The defendant allegedly solicited the complainant to engage in an act of masturbation of each other. The complainant testified the defendant told him not to tell anyone that this happened. It could get him in trouble. Afterwards, the complainant thought that this act would assure him that he wouldn't lose his internship. In September of 2003, the defendant asked the complainant to work for him again, this time at Fox 2 story covering a concert at Joe Louis Arena. Afterwards, the defendant drove the complainant back to the defendant's home on Washington. He again allegedly solicited the complainant to watch another pornographic home video, this time involving the defendant engaging in an act of sexual penetration with another individual. The defendant then allegedly solicited the complainant about whether he wanted to do that, and the complainant agreed, and then the defendant allegedly led the complainant to his bedroom and engaged in sexual penetration. The defendant again told the complainant not to tell anyone that it was wrong and that the defendant could get in big trouble. The complainant testified it confused him why the defendant would do something he admitted would get him in trouble, but he wanted someone with the defendant's connections in his corner. In October of 2003, the defendant, now 15, asked the complainant to clean his apartment, and afterwards asked the complainant if he wanted to do what we did last time, and they engaged in another act of sexual penetration. The complainant testified he felt he was still working for the defendant, and the sex was required in exchange for the defendant's mentoring the complainant. He further testified that he considered the defendant a mentor, someone who could help him make connections, including in the LGBT community in Detroit. Complainant testified that the sexual penetrations occurred on at least 4 other occasions, one in January 2004 after they dined at a local restaurant, again in April 2004 after meeting the mayor, and two other situations, all occurring before the complainant was 16. Criminal sexual conduct, among other things, requires in this case a showing that the defendant sexually penetrated the complainant under one of the statutory aggravating circumstances. For purposes of this motion, the issue is whether the lower court abused its discretion in finding the defendant was in a position of authority over the complainant. In this court's view, the lower court did not. In this court's opinion, the issue is not determining the complainant's employment status as an employee, intern, or part-time personal assistant. The issue is whether the defendant's actions put himself in a position of authority over the minor. The Court of Appeals found in People v. Reed, 233 Mishap 457, 2009, that a church counselor who obtained prior permission from a child's parents to privately mentor their child gained a position of authority over that child, particularly when the minor was aware that parental permission was given. In Reed, like here, the parents gave the defendant permission and entrusted their child to the defendant to spend time alone together. This was sufficient for the Court of Appeals to affirm a jury finding of position of authority. I also find that it's a sufficient basis to conclude that the lower court did not abuse its discretion in finding that the defendant was in a position of authority over the complainant. There is also, in this court's view, evidence to support the lower court's decision as it relates to whether the defendant used this authority to coerce the complainant to submit. The people argue that the defendant used his celebrity status, the allure of going on media events, the prospect of being and the prospect of being able to report this experience on a resume, and that this was manipulated by the defendant and amounts to implicit coercion. The law is clear that coercion can be actual or implied, and it's determined from the totality of the circumstances. That's People v. Reed again, and also People v. Brown, 197, Mishap, 4/8/1992. The lower record makes clear that the complainant engaged in sexual acts, at least according to him, at least in part, for these reasons. Therefore, I cannot find that the lower court abused its discretion in finding that this authority was used to coerce the complainant to submit. Lastly, the defendant asks this court to quash the information or the people's alternative theory that the defendant committed the crimes of first-degree criminal sexual conduct during the commission of a felony, specifically that the accosting a child for immoral purposes was inappropriate because the statute of limitation on that predicate or underlying felony had run. Since this is an issue that is related to the statute of limitations issue, I will address it for purpose of that argument. But to be clear, defendant's motion to quash the information, at least on the issues that I've addressed so far, is denied. For purpose of the statute of limitation, the defendant asked this court to dismiss the alternative theory of criminal sexual conduct first degree involving accosting and soliciting as the underlying felony, and counts 4 and 5, which involve criminal sexual conduct third degree, because these counts are time barred by Michigan's statute of limitation. Defendant argues that these charges would have to have been filed no later than May of 2014. In this case, all the charges are alleged to have occurred between September 2003 and May of 2004, when the complainant was 14 and 15 years old. And there's also at least argument to support that the complainant filed the police report in November of 2015 when he was 27, and a warrant was issued in June 22nd, 2016. And the defendant had resided outside of the state for a substantial amount of time during that time frame. With regard to the criminal sexual conduct first degree charges, defendant is essentially arguing that since the 6-year statute of limitation for accosting and soliciting a child for immoral purposes precludes him from being charged for that crime, that same crime cannot be used as an underlying felony for criminal sexual conduct first degree. In other words, the prosecution for criminal sexual conduct first degree is dependent upon the state's ability to prosecute the defendant for the subordinate crime. Other than the statute of limitation, the applicable statute of limitation statute, no other case law is offered to support this position. It appears to be an issue of first impression, at least in terms of the criminal sexual conduct first degree statute. It's noteworthy, however, that the criminal sexual conduct statute states as follows: a person is guilty of criminal sexual conduct in the first degree if he engages in sexual penetration with another person who is at least 13 but less than 16 years of age, and the sexual penetration occurs under a circumstance involving the commission of any other felony. There's no language requiring that the defendant be convicted of the underlying felony, only the elements of that crime are satisfied. The felony murder statute, in this court's opinion, is instructive and analogous to the situation here. Like the criminal sexual conduct first degree statute, the legislature made the commission of another felony an aggravating factor used to enhance a lesser offense to a greater offense. In People v. Seals, 285, Mishap, 1, 2009, the Court of Appeals had to settle a similar issue when it was asked to invalidate a felony murder conviction because the underlying felony was barred by the statute of limitation. The court, in that case, held that the expiration of a statute of limitation for the predicate felony did not bar the defendant's conviction for felony murder, and the felony murder statute does not require the defendant to be charged or convicted of the underlying felony, only that the murder occurred during the commission of a specified felony. The first-degree criminal sexual conduct statute does not require a defendant to be charged or convicted of accosting or soliciting a child for immoral purposes, only that the penetration occurred during the commission of that crime. If the legislature wanted to require only viable predicate felonies that were not time-barred, then the legislature could have expressly done so, but it did not. Therefore, defendant's motion to dismiss the people's alternative theory as to counts 1, 2, and 3 under the statute of limitation grounds is denied. In support of his request with regard to counts 4 and 5, that's the criminal sexual conduct charges, the defense argues that incites MCL 767.24, which allows for first-degree criminal sexual conduct to be filed at any time, but requires all other criminal sexual conduct offenses to be filed within 10 years of the offense or by the victim's 21st birthday, whichever is later. Under that statute, I should say under MCL 767.243A, an indictment for a violation of this crime may be found within 10 years after the offense is committed or by the alleged victim's 21st birthday, whichever is later. So here, without further information, criminal sexual conduct third charges should have been filed no later than May of 2014. However, the people argue that the defendant did not publicly reside in the state during this time. This is a point that's not contested, at least at this hearing, by the defense. And there's a recognition by the parties that if that were the case, the statute of limitation is told. In support also that this is a jury question, not a question of law, the people cite People versus Allen, 192 Mishap 592, 1992, and People versus Artman, that's A-R-T-M-A-N, 218 Mishap 236, 1996, in support of that position. And this court agrees. Therefore, defendant's motion to dismiss and or quash due to the statute of limitation is denied. I think that covers the statute of limitation issue as well as the motion to quash issue. There are a number of other issues that I'd like to address as well. What issue would you like to cover next?
The motion for attorney conducted for a year, I believe the prosecutor's in agreement with that.
Yeah, that's something we discussed at bar. I can tell you my typical policy is that in capital cases, I'll give each side 30 minutes for the initial panel and then additional time after that. I also offered if either side would like to submit any specific questions that you would like to have come from the court, I'm prepared to do that, provided I view it as a proper question. I'd be happy to ask any additional questions you'd like me to ask on your behalf. There are perhaps some unique issues that you may want me to cover in this case, and might be better from the judge than the litigant. So I'll leave it to you. If you want to submit those in advance, I'll review them and we'll have a discussion. But your request, I guess to make it a little bit more formal, your request for attorney-conducted voir dire with those clarifications is granted.
Thank you. There's a motion for the criminal history of witnesses. Now, the prosecutor tendered a witness list today. It has a number of people that are on the list. Not all have been endorsed. However, it's probably more applicable to the motion that's going to be argued as relates to 404B in terms of the criminal history of those particular individuals. So I don't know if we want to wait for that, but any witnesses that they have that they've actually ran a lien on, I know that they are not required to do that. If they have information, we'd like that information to be turned over as relates to the criminal record that they have. I do have some information on Daniel Peel, as well as Jason Mann. However, I'm limited in terms of what I do have, and if they have some additional information, then we're asking that that be turned over to the defense.
Yeah, and I have no objection to that. Those are the two individuals that I have some information on. I'm happy to turn over what I have to counsel concerning that. As to the rest of the witnesses on the witness list, as of now, I do not have any criminal history as knowledge of any criminal history of those individuals. But if something should pop up, I will certainly get that to counsel.
All right, so one of the issues that could surface is I imagine some of the individuals on the proposed witness list may well, let me back up a little bit. In terms of what you happen to have in your file, you're also, of course, responsible for anything that your office has. So, for example, if you have a file in the juvenile section of your office, and in that file there's a criminal history, that's going to be imputed or expected that that would be in your possession.
And that's fine. However, the criminal history aspect should be, I believe, limited to a conviction or a felony involving theft and or dishonesty that's fallen within the 10-year period that I think the court rules require.
Right.
That is, and with that in mind, juvenile histories do not record, I mean, they're not felonies. So
Why don't we do this? The first step, I think, is for you to determine what's in your possession, what's not in your possession. If you feel as though there's something that is in your possession that either should not be disclosed because it's inadmissible, or should be disclosed, but there are things on the criminal history that are inadmissible, things that have nothing to do with theft or dishonesty, then you can provide that to the court for an in-camera review. But I think the first step is for you to determine what's in your possession.
all right, now, things that would be in my possession that are open to the public would be such as, and I'm thinking in terms of juvenile records. Juvenile court files are open to the public. They can go and get that information on their own. I don't need to, I mean, that's a court file. The prosecutor's file in those cases are, well, if they are in our possession, we'll look at that and provide that. Court files are open to the public. They can go down and they can get those. So I would leave that to counsel. I can indicate to counsel if I know that there is. I'll be more than happy to do that if I'm aware of it. But if it's in my possession, I certainly will, as a court instructor.
Well, Judge, one of the issues relates to Nathaniel Hill, who is one of the persons that we're seeking to admit under 404B, which we'll argue next week. And because of some of the allegations that have been set forth relating to Mr. Hill's quote-unquote working for Mr. Pugh, the incident occurred in 2016 in terms of the theft-related offense. That information is definitely relevant and important for our defense. And so if I have to get it by virtue of going to juvenile court, then I'll get that. But if they already have the information, then that's to be turned over. Then the court can decide whether or not it should be allowed.
Yeah.
You know, but so everything that's discoverable doesn't necessarily mean that it can be used. But certainly, I think that information will assist us in our defense.
All right. So just the record's clear. Your motion for the people to disclose relevant criminal histories within its possession is granted.
Thank you. An additional motion for Brady materials and additional discovery. We have had an opportunity to discuss that matter. I have a number of items on in the motion that I still need, notwithstanding the fact that a lot of information has in fact been turned over to counsel, but there are some additional things that are noted here, and Mr. Elizondo has indicated what they have and don't have, but he's offered to allow me to come and take a look at the
This is with regard to which issue?
This is the additional motion for additional discovery,
Okay.
as well as Brady is just general, just make sure that you give me what we're entitled to.
All right.
So I won't necessarily argue that, but just a standard Brady motion that the things that they're required to turn over, then I'm asking if they do that, and then the motion with respect to additional discovery. There is one thing that I specifically want the court to order, and that is either a birth certificate or some identification relating to the complainant's age. There was a document that I reviewed from the mom that had a birth date that was different than what Mr. Williams is indicating. And so his mother, of course, should know when he's born. And maybe she was mistaken, maybe the